Hello everyone, welcome back once again to yet another video on Polity Daily Drill. This is day 3, the time is 8:30 and let's begin. First up, consider the following statements regarding the basic structure doctrine of the Indian Constitution. The basic structure doctrine was established by the Supreme Court in the Keswanand Bharati case of 1973. The doctrine specifies certain features such as rule of law, separation of powers, and judicial review that cannot be altered or abrogated by a constitutional amendment. And Statement 3, under this doctrine, no amendments are allowed if they seek to remove the fundamental rights. Now let's solve this question. First statement is absolutely correct. We know very well on the 24th of April 1973, a 13-judge bench with 7:6 majority gave its judgment and came up with a concept of the basic features which came to be known as the basic structure doctrine, that there are certain elements of the Indian Constitution which they said would be the essence of the Indian Constitution, the value system of the Indian Constitution, the cornerstones of the Indian Constitution. Those things, those aspects, those provisions can never be modified, can never be amended. So, of course, first statement is correct, and so is the second statement. Why? Because, as I just said, certain features cannot be altered or abrogated, taken away, removed by a constitutional amendment. However, third statement is actually incorrect. It of course can be very easily proven through this fact that through the 44th Amendment Act of the year 1978, the Janata Party government made a modification in the fundamental rights. One Article 19(1)(f) was removed. The right of every citizen to acquire, to hold, and to dispose of property was removed. And one more Article 31 Clause 1 was taken out of Part 3 and placed under a separate Article 300A, made into a constitutional right rather than being a fundamental right. And fundamental right was also repealed. So the fundamental rights are amendable. What is not amendable is the essence underlying the fundamental rights. That cannot be modified. The right per se, the right in itself, can be modified. So 3 is wrong. How many statements are correct? B, 2 only are correct. Moving on to question number 2. Consider the following statements about the Citizenship Act of 1955. Citizenship Act is the law made by the Parliament. Why? Because matters dealing with citizenship, the acquisition of citizenship, the loss of citizenship, these matters are dealt with by the Parliament because it's a unionless subject, and also because Article 11 gives the Parliament this authority. So a law has been made which provides for ways in which citizenship can be acquired and also ways in which one can lose their citizenship. First one, the provision relating to the loss of citizenship via deprivation is limited to those who have obtained citizenship through registration or naturalization only. Now this statement is absolutely correct. Why? Because deprivation which is done by the government of India, see, there are certain ways to lose your citizenship, like of course renunciation or even termination. These happen automatically, but when somebody gives up their Indian citizenship, or if the person acquires citizenship of some other country, these things come into force. But as per section 10 of the Citizenship Act, the government of India can take away your citizenship, but it is meant for only those people who have obtained it either through registration or via naturalization. So one is correct. Second one, once India acquires a foreign territory, all the people residing in the area become Indian citizens automatically. So imagine a situation where, let's say, India takes over, captures Pakistan. Now, all the people of Pakistan, will they become Indian citizens automatically the moment India captures Pakistan? Of course, this is not correct. Why? Because whenever India acquires any foreign territory, as per section 7 of the same law, the Citizenship Act of 1955, the people of the area do not get citizenship of India automatically, but the government of India will have to issue a separate notification for the same, and only after this notification will those people be given the Indian citizenship. So it might happen that India occupies Pakistan and all the people of Pakistan are still denied Indian citizenship. They are still considered to be aliens. So 2 is wrong, 1 is correct. Which of the statements given above is or are correct? A, 1 only. Now moving on to the third question. Consider the following statements regarding court of records in India. A court of record is a court whose proceedings are permanently recorded, making its judgments, proceedings, and acts official legal evidence. Now, in our country, the superior courts, what are these superior courts? The superior courts are the Supreme Court and the High Courts. These courts are called Court of Records. Supreme Court as per Article 129, High Courts as per Article 215. And what is the speciality? What's the meaning of Court of Records? This is the meaning of Court of Records, that the decisions, the verdicts, the judgments, the proceedings have evidentiary value. They can be used as evidence, they are used as precedents by the lower courts. So 1 is correct. Also, such courts also have the authority to punish for contempt of court. Second statement is also correct. Both 1 and 2 are correct. The right answer is C, both. See, the second statement, which says that court of records have the power to punish for contempt, is correct. This is a very old standing situation in our country. Even before the independence, in the British times, one federal court did make a statement like this. There's a very old judgment, Abdul versus Mahatab case of 1867, where it was held by the courts that every superior court has the power to punish for contempt, and this has continued. In fact, there is one more additional feature of Court of Records. And what's that feature? That additional feature is that these Court of Records have a power, or the power to revise their own decisions, their own judgments. So every Court of Record can also revise its own judgments. This has been said by Supreme Court in the Shivdev Singh case in the 1960s, recently again in the year 2020, right? So both Supreme Court and High Courts have the power to revise their own decisions. Both 1 and 2 are correct. Right answer is C. Moving on to the fourth question. Which of the statements regarding the impeachment of the president is incorrect? Impeachment of the president is mentioned under Article 61. It's imperative that you read Article 61 on your own as well. First one. The process of impeachment can be initiated in either house of the parliament. Absolutely correct. The process can be initiated by 1/4 of the members at least 1/4 of the total membership of either house, Lok Sabha or the Rajya Sabha. Then a 2/3 majority of the members present and voting in the house is required. Now this is wrong because 2/3 majority of total membership, the total strength of the house is required to pass the impeachment motion and not just present and voting. So B is incorrect, hence becomes the right answer. Let's look at C and D as well. The president can be impeached for violation of the constitution only. Yes, that's correct. The only ground, the only reason that is mentioned in the constitution with respect to the impeachment of the president is the violation of the constitution. And please be sure that there is no definition of what constitutes violation of the constitution. And the fourth one, the president has the right to defend himself or herself through a nominated representative during the impeachment process. This is also correct. So right answer is B, which was the incorrect statement here. Let's move on to the last question for today. Fifth one. Which of the following are the members of the Delimitation Commission? Now the Delimitation Commission, formed under the provisions of Article 82 of the Indian Constitution, comprises of retired Supreme Court judge, Chief Election Commissioner, and for the respective states, the State Election Commissioner as well. SEC, the State Election Commissioner, is also a constitutional body under Article 243 capital K. For every state, you have a separate SEC. So, the Delimitation Commission comprises of these three people, neither the Prime Minister nor the Speaker of Lok Sabha. Hence, C, 3 and 4 is the right answer for this question. That brings us to an end of our discussion for today. And that is all for this video. We'll meet in the next video, that's tomorrow at 8:30. Till then, that is all for me. Jai Hind.